Hello, welcome to the HKK Law Office's YouTube channel. I'm Kyle Kaufman, a family law attorney in Wisconsin. Today we're tackling a video I came across called Get the State to Drop the Child Support Case Against You. Now, this video was interesting to me. It offers advice on how to avoid paying child support by requesting financial documents, filing motions to compel, and ultimately filing for contempt, and hoping to get the case dismissed in that way. So while this approach may sound appealing to some, what I discovered is that it overlooks crucial aspects of Wisconsin law. So let's set the record straight. The video and the content creator suggests a multi-step process. And the first is when you're served with a request, a petition to pay child support, is to demand financial documents like pay stubs and tax returns, leases and bank statements, and you'd request that from the other parent in the action. The parent seeking support, it suggests, won't turn over the documents that you request. And as a result of that, then you can bring a motion to compel when the other parent does not comply. The suggestion that you would then be able to obtain an order requiring the other parent to comply. You would then file a motion for contempt if the documents are still not produced by the other parent. And the final step is at a contempt hearing, you would request the court to strike the pleadings of the parent seeking child support, which allegedly results in the case being dismissed. What I do like about the content of the video is that the creator is suggesting being creative and proactive. And frankly, he's right. We believe in that at HKK Law Offices too. It's a good idea to become involved in your child support matter and care about it and take the steps to prepare for your court matter and to defend yourself. What I do not like is that the steps outlined miss the mark and could potentially not be relevant at all to your matter, or it could lead to an outcome that is something other than a dismissal. The claim made in the video sounds so simple, but it ignores the nuances of child support law in Wisconsin and maybe in your state, and particularly when it comes to the relevance of the other parent's income, which I'll break down. So I want to talk about why the claim's misleading, okay? Now, let's address the main issue of the content creator is that the assumption is that the other parent's financial information is always relevant. And in Wisconsin, unfortunately, that's not true in many cases, and especially the ones that are initiated by the state of Wisconsin Child Support Agency. Sadly, in Wisconsin, I see courts often overlooking the income of the other parent that is seeking support. And that parent who has the primary physical placement's income is just not considered by a judge. And this is despite the Wisconsin statutes that require both parents to file a full and complete financial disclosure statement, which would typically also require them to turn over documentation like tax returns and pay stubs. And they're supposed to be doing that in any action that's affecting the family. But the reality, regrettably, is that many judges simply do not care about the income of the parent who has primary physical placement. So the question becomes then, when does the other parent's income matter? It must matter to some degree and at some point, right? And in Wisconsin, child support is typically calculated using the percentage standard, and that primarily considers the income of the parent who does not have primary placement, the payor. And so if one parent has primary placement, the income of the parent with primary placement is just irrelevant. It's overlooked in the calculation. And that means that issuing demands for financial documents might not even apply to your situation. And the court overseeing your case simply will not require the other parent to disclose the information. They might just say, so what? Why does it matter? You do not have shared or equal shared placement. And that gets us to the terms that Wisconsin uses, and you need to know your situation with placement. Wisconsin uses the terms primary placement, equal and shared placement, and the third one is shared placement. So what we want to talk about now is when the financial documentation might be relevant to your case in Wisconsin. And there are scenarios when requesting the financial documents can be relevant, but they're specific. In a situation where we have shared or equal placement, it's certainly relevant. In that situation, both parents have equal placement, and the court considers the income of both parties to calculate child support. When the parents share placement, meaning that each parent has at least 25% of the overall placement time, in that situation, again, the court would consider the income of both parents to calculate child support. Another scenario where it could be relevant to have the person's financial information and documentation is when you're asking the court to deviate from the guidelines. It's called a deviation from the guidelines. The statutes in Wisconsin speak to this. It says if either parent's asking the court to deviate, then the financial circumstances can come into play, and courts can deviate from the standard child support calculations for a variety of reasons. It could include things like fairness to the child or to a parent, extraordinary travel expenses, educational needs, the tax consequences of the situation, health insurance costs, and child care costs. Now, the third scenario where the financial documents could be relevant are in situations where you have a combined child support matter and maintenance. It's called alimony in other states. And their financial documentation is relevant because the court is overall looking at the needs of the other parent that are in addition to the child support needs. Really, the important takeaway here is that you need to check your case specifics, your placement scenario, before you pursue these motions to compel or contempt, and really understand what you're asking for and how it's relevant to your case. So let's talk about pretrial motions in Wisconsin and the reality of that. And what I mean by that is the approach suggested in this other video is problematic in most child support cases in Wisconsin. So a motion to compel, if the financial documents are irrelevant to the child support calculation, then the court is unlikely to grant your motion because the court is going to say, look, we just don't need that information to decide this case. On a motion for contempt, all right, now that's after the person has not produced the information. Filing for contempt only works if there's a valid court order to produce the relevant documents that hasn't been followed. So again, you have to show the court, prove to the court that first the documentation is relevant to your case, then if the person doesn't provide it, you can bring a motion contempt. But oftentimes still there, the court will not find people in contempt. They'll give them opportunities to bring in the information. And courts are just really reluctant to take that step at times, unfortunately. Dismissal of the claim is really at the heart of this, right? The video suggests that you take these simple steps and the court will just dismiss the claim. And that's an extreme remedy. Courts rarely grant that. And it's really unlikely to apply in a straightforward child support case in Wisconsin unless there's really egregious misconduct. And so what my concern is that what's suggested in the video is easy to attain, and I just disagree with that notion, and I think it's important that you know that. The practical advice for you moving forward in your case, is this. First ask yourself, what do I do? If I'm facing a child support petition in Wisconsin, what are the steps? Number one, understand the law, right? Know how child support is calculated in your case. Know what your placement schedule is. If you do not have shared placement or equal and shared placement, the other parent's income is less relevant to the court's ultimate decision on child support. You need to know that going in. Number two, hire an attorney. Don't just consult with an attorney. Consult with 3 attorneys, in fact. Pick one that's best for you. But if you're really concerned about this and child support and your money and how this all impacts you and your children, then a family law attorney can guide you based on your unique circumstances. And number 3, focus on the relevant defenses in your case. Consider defenses that matter, like challenging the income calculations, what they think you earn. Make sure to explain to the court what your actual income is. And you also need to demonstrate that you do have shared placement. There are, unfortunately, some situations where the order might not actually say you have shared or equal shared placement, but in reality you are exercising that and actually following that informally. Tell the judge that. Finally, what I want to address is going back to our original video that we discussed. And that suggestion by that creator, that suggestion in that video might work in certain jurisdictions, different states, or under specific circumstances. I'm not saying it will not work, but it's not a one-size-fits-all solution. And certainly not in Wisconsin, for the reasons I've outlined here. The courts are guided here by well-established laws and principles, and understanding those is key to building a strong defense. Here are my final thoughts on all of this. Number 1, I want to bring clarity to you and clear up any misconceptions about how easy it is to navigate through child support cases and ultimately have your case dismissed. If you're dealing with a child support case and you need personalized advice, call an attorney. Feel free to contact my office. We're at www.hkklawoffices.com. Thanks for watching, and I'll see you next time.